We're now going to the defense to hear their response. Take a listen.
You can't get 12 people off the street to agree as to a very important decision. So I thank them for all the work they did. Some of them were willing to talk to us, and so my sense is that they worked very hard to come to a conclusion, and sometimes you just can't.
Can you talk about the reaction from Christopher
Schurr? He's been living with this for 3 years. He obviously wanted some resolution. I think he felt that the jury took the time to deliberate, and he appreciates that. He obviously wanted it to be done, but it's a hung jury. So I haven't had much chance, obviously, to talk to him yet because I've been talking to the jurors. So he'll probably have to reflect on it, as we all will, and as will Mr. Becker, on how we proceed next.
What do you think about the possibility of a retrial? I mean, what do you think should have happened?
I do not think this case should be retried. I don't think it should have been charged in the first place. I think that it was clear, based on the evidence, that there wasn't enough to establish a charge in this case. I think there was a lot of evidence at trial that was irrelevant and that shouldn't come in. And so if there is going to be another trial, we're going to likely seek rulings from appellate courts as to what evidence is put before the jury. In particular, I do not believe that this theory that was sponsored by Professor Stoughton, how an officer can put himself in jeopardy by following what he believes to be poor policies of GRPD, where he loses the right to defend himself should he later be put in a position where someone is about to use, he's an imminent threat of bodily harm or death. I think that's absolutely wrong. I think the jury was confused by the fact that the prosecutor was saying that he cannot defend himself because he screwed up on whether or not he should chase him. I think that had effect on the outcome and the fact that they couldn't reach a unanimous verdict. And so if there is going to be another trial, we're going to be asking the Court of Appeals to decide whether officer-created jeopardy is something that should apply in a criminal case, and whether officers, if they make any negligent act early on, they can no longer defend themselves if someone turns on them with a dangerous weapon.
Were there a number of appealable issues that you saw during this trial?
Yes.
Can you talk about those, other than what you just spoke of?
Substantively, that's the main issue. And to those that are following legal opinions, there was a U.S. Supreme Court case just in the last 6 months called Barnes v. Felix, where this exact issue was argued extensively. I think that this officer-created jeopardy is incredibly dangerous, not only for police officers who are asked to put themselves in dangerous positions, but for the community. Because what's going to happen if you instruct officers that they cannot arrest somebody, and it's up to the person being arrested to decide whether they're not going to be arrested, you're going to see a lot of officers who are going to hold back and be instructed that if later on this person has a gun or gets a dangerous weapon and uses it on me, I can no longer defend myself because I've screwed something up early on. So that's the primary appeal issue. We, as you know, Mr. Coker, we briefed that extensively before the trial. We tried to exclude it all for the trial, but yet it became the central issue. It's clear to me, if you listen to the prosecutor's closing statement, that he talked about the chase and whether or not that was reasonable, when the issue should have been whether at the moment of the threat, whether Christopher Schurr was in fear of great bodily harm or death, and whether he acted as a reasonable officer would in that situation. So that's,
sorry.
Go ahead, Duncan, right?
Sam.
Sam, sorry.
The decision for Schurr to testify, how and when was that made?
We anticipated he would testify, and as we saw the proofs come in, we felt that it was important for the jury to hear from him because it's a case where what he was thinking, what he was feeling is important, And while there were plenty of experts on both sides to talk about whether it was reasonable, the only person that could say what was in his head is Chris. And, it was a matter of, well, if something happens where he shouldn't testify, we won't have him testify. But the plan was he was going to testify unless something happened.
Do you know how that played with the jury? Have you spoken to the jury about his testimony, what difference that made at all?
I think they considered it. I don't think anybody thought he was dishonest in his testimony. Obviously, we didn't talk to a lot of the jurors, and I'm not going to get into the specifics of what they're telling us, but I think it played a role, but wasn't the dispositive witness.
You can't tell us how close they were one way or the other? Was it 11-1 one way, another way, half, 50-50? Can you talk about that?
It was overwhelmingly in favor of acquittal, and there were holdouts on the other side.
How many holdouts?
I don't know for sure.
How long were you talking to the jury after the mistrial was declared?
I don't know, from the time of the mistrial until I came down here, I don't know how long that was.
During close, you had mentioned that you didn't have to put on a defense, but you did because of the importance of the case. Moving forward, should this be retried again, are there different approaches that you may take? I know you can't get too much into strategy, but were there things that you left out this time that maybe you think next time would be appropriate to bring in?
It's kind of speculative. I don't know. It would depend on what the trial looks like going forward. I mean, if we're arguing about whether or not he was negligent in chasing him, then I'm going to have to address that again. I just don't think that should have been ever put before the jury. And because it came down to whether or not GRPD's policy or no policy on foot pursuits has some sort of bearing on whether or not he can use deadly force to protect himself. And I think over half the trial was about irrelevant evidence. You had experts on both sides talking about how close you can stand to somebody when they deploy their taser. I don't know how that relates to a minute and a half later when Mr. Lillia has exclusive control of the taser and is turning. It shouldn't matter. I was flummoxed by the fact that an expert could get on the stand and say, because you're too close, Mr. Lillia grabbed the taser. That was a decision that was made by the individuals that were in that situation, and not because of some GRPD policy.
Matt, you asked for a mistrial on my count 3 times, maybe it was 2.5. And Judge Min said you put something in the motion about rolling her eyes. What did you think of the judge in this case? And was this a fair trial? You keep asking for a mistrial. Was it ultimately fair? Did she do a good job?
We asked for a mistrial, and the primary reason was because there was all this evidence put before the jury that we did not think was relevant, and that was the focus of the prosecution's case. As far as the allegations of facial expressions, we obviously don't make those allegations unless we're certain that they're occurring. It was a crowded courtroom. It was our belief that the judge had been communicating with the jury. Why she might be biased, we never suggested one way or the other. We just thought that her demeanor at times suggested that she had feelings about something that coincided with the testimony.
So someone on your defense team actually saw her rolling her eyes? Is that what you're saying?
Yes.
How many times? Can you talk? Was it often? Was it frequent? One time?
Throughout the trial, we thought there were facial expressions and didn't raise it. And then when Officer Schurr testified, we believe that there were facial expressions that were communicating something to the jury, and that's why we filed the motion. I have, yes.
Sorry to interrupt you. When you said earlier that the jury was in favor of acquittal, do you mean acquittal on the second-degree murder charge or voluntary manslaughter or both?
Both.
So if you're just joining us live, you're looking live on the left side of your screen. The defense attorney for Christopher Schurr is speaking following the mistrial declaration. On the right side of your screen, the civil attorneys for the Lillia family, as well as much of the Lillia family, is also giving their remarks.